Good day, everyone. Welcome to the Landrum HR webinar on Employment Law 101, Part 1. Let me take a moment to introduce myself. My name is Becki Haines, and I have over 25 years of human capital expertise. I hold a business degree with a concentration in HR, and I'm certified as a professional in human resources by the HR Certification Institute. I also hold both my certified professional as well as my people analytics credentials through the Society of Human Resources Management. As an 11-year Landrum HR employee, I've worked with the staffing, PEO, and consulting divisions of the company. I currently hold the position of managing consultant. Prior to joining Landrum HR, I was the director of human resources for the largest behavioral healthcare system in Alabama, where I led the HR team in the proper execution of the recruitment, employment, benefits, compensation, workers' compensation, and safety disciplines for over 1,000 staff. I am passionate about helping organizations best manage their greatest resource, their people. A teacher at heart, I really enjoy focusing on helping business leaders understand the why behind the what so that they can move forward with confidence in their decisions. Now, today, we will be starting with some basics that each leader should know when going into a supervisory role. Many of you may be first-time supervisors, or you may be seasoned leaders desiring a refresh of the basics. In an effort to gauge the audience, I'd like to start with a poll. How many years of supervisory experience do you have? 0 to 2 years, 3 to 5 years, 6 to 9 years, or over 10 years? I'll give everyone just a moment to answer. And it looks like we have a really good mix today. About a third of our audience is fairly new to their supervisory role, and it looks like a little over half have more than 10 years of expertise. So hopefully this will be a good refresh for some of you and a good starting point for the rest. All right, so being a new supervisor can be a little bit scary. I know about a third of you are in that boat, and it looks really cool from a distance. But when you become one, it can be a little unnerving as well. You may be looking for your roadmap to lead your team, but there is no surefire roadmap as you're dealing with people. People come with all different kinds of shades of gray with them. There's no Bible of sorts to hand to you to say, do this or don't do that, and it will, produce really great results for you. Kind of like those of us who have children, I don't know about your experience, but I know when I had my daughter and they rolled me out of the hospital in the wheelchair and handed her to me and said, good luck, I can remember thinking, are they just going to let me leave me with her? I mean, like, I've never been a mom before. Do they know this? There's just this overwhelming feeling of insecurity when we're dealing with people because there's no formula. There's no formula to guarantee success like there might be in a non-supervisory role. But ultimately, that's why this is a higher level position, because there's great difficulty surrounding it. Now, one thing we can do, though, is we can learn from common mistakes that we see new supervisors do out of the gate. Think back over the leaders that you've had in your career. You may have had an over-controller or an under-controller at one point. Employees that work for over-controllers, they often feel like, well, why did they even hire me? Do they not think I'm capable of doing my job? They tend to bark orders, they tend to give responsibility, but with very little authority, and they tend to have too little autonomy. Now, if you've had a boss like this in the past, and a lot of us have, you know what I'm talking about. This can be very demoralizing. You feel as if, you don't have complete ownership over anything, and you feel like you're not trusted to do your job and do it well. Under controllers, on the other hand, tend to be all ears and use too little authority. They give far too much freedom and very little feedback. Now, the employees that struggle the greatest with this type of leader, they're your type A's. They are desperate to know that they're hitting the mark, that they're doing well, But with little to no feedback, this brings great insecurity to them. Now, the point here is that as leaders, we don't want to be one extreme or the other. It's best to be a leader that both gives control to the employees to own their work, but also gives them helpful feedback along the way. It can be a little unnerving to make the transition from a non-supervisory employee to a supervisor. Now you manage other people's time. Long gone are the days where you could sit down with your to-do list and cross it off one by one, feeling very satisfied with yourself. I know if you're like me, I love a good to-do list, and if I even find an old to-do list, I'll still cross everything off before I throw it away. Your satisfaction is going to have to come from other sources now. It may be that light bulb moment that you see one of your staff have when you've been working with them for some time on an issue. It may be watching a deeper level of teamwork take place in your department. Your satisfaction is now going to be based off of team development rather than a list of to-do items being checked off. But understand that you now have long-term concerns. I mean, when do you really cross off your list, fully developed my team? Never. It may very well seem like an endless process to you. And again, that is why finding your satisfaction in the more abstract is highly necessary. Now your key resources are your staff, not your own capabilities. I assure you that you will now be judged on the health and the strength of your team going forward. I've often been asked to go into companies and diagnose issues within a department or a team, and it may be something as simple as extremely high turnover with one team, or maybe low productivity, maybe a number of employee relations concerns that are rearing their ugly head. But whatever the issue is, I guarantee you that at some point, the senior leaders of that organization will turn and look at me and say, Becki, do you think we have a leadership problem? You see, your team's success or failure will ultimately result in your own. So make sure you're doing everything you can to support your team's success. And finally, remember there's a difference now between the job that you hold and the jobs that you supervise. No longer can you stand at the proverbial water cooler and gossip. Your words now have weight. You have greater access to information now. You understand your company's inner workings to a greater degree, and you're now considered an agent of the company since they placed you in a leadership role. Now, one of the more common issues that we see with leaders is the struggle they have going into the unknown. Most first-time supervisors are placed in that role because they're very good at their previous role, so good that they were now deemed worthy to lead the team. The common struggle, though, is while they're being pushed into a number of more gray and ambiguous roles where they're not yet confident in their skill set, that old role is calling their name because they knew when they were hitting the target there. They knew what success looked like there. So the danger here is being pulled back and not pushing yourself and growing into a new set of skills. Now let's talk about some different relationships that supervisors, whether new supervisors or seasoned supervisors, will oftentimes find themselves in. Those that may have been promoted from within their organization are more likely to run into this scenario, the scenario of supervising friends. A few tips for dealing with this are, first and foremost, be upfront with former friends about your own concerns about being a friend and a supervisor at the same time. Employees crave transparency and honesty. Don't just move on like nothing has happened. There's an elephant in the room and you need to address it. They'll respect you for dealing with the matter head on. Be prepared to be honest about how the dynamics of your friendship very well might change. Pledge to work towards a positive goal. Remember, you're obligated to get the job done first. Then be on the lookout for others who may view that relationship based solely on your friendship. Now, this area can cause you great grief amongst your staff. It can also cause your friend problems. There's nothing wrong with saying, hey, for your sake, and so no one ever looks at our relationship as you getting preferential treatment, we'll probably need to forgo some things like we did in the past, like going to lunch one-on-one. Finally, remember, your friend is not your work confidant. You'll now have access to information that they do not. You can't divulge that information regardless, so there's going to have to be a strong line drawn. Now, many, if not all of us, will at some point manage staff that have more experience than us, and that's okay. You're not a leader because you're the smartest. You're not a leader because you're the most well-educated or you have the most experience. You're a leader for one reason and one reason alone. Your company believes you have a well-rounded set of skills to move a team of people forward. So don't sweat it. Shine the stars of those on your team. They're not a threat to you. Be comfortable in your own skin. Remember that education isn't everything. Often what people lack in education, they make up for in experience. So tap into that. In many cases, more experienced employees know more about the job than you do. So try to create an atmosphere of no competition and strive towards a more positive relationship. You know, there is a very fine line between creating a competitor versus creating a supporter. And it has everything to do with whether or not you're confident enough as a leader to shine their stars. Let's say you go into a leadership meeting and you brag on what you had accomplished within your department, but you took the credit instead of giving the credit to your employee. I promise you that before you get back to your office, that team member will know what you said, and you will instantaneously become their competition. However, if you've gone into that meeting and bragged on your team member that handled the project so smoothly, that they came in under budget, they came in on time, and man, they had some great ideas, that also would have gotten back to your team member just as quickly, except that this time it's met with great loyalty. And you've now created one of your biggest supporters and taken any competition out of the relationship. Remember, length of service on the job often shows commitment. Get them involved. Seek out their help in training and mentoring new people. You know, people often say, Becki, I have this one employee that I so wish I could clone. And my answer is always the same. You can. You need to set them up as a mentor or a buddy to your new employees. Show your new employees from the get-go what the standard is from day one. Now, even though these more experienced employees have some time under their belt, expect them to change with the times. Don't expect them to say things like, oh, that can't be done, or we've tried that before, or it'll never change. They may have some valuable information to impart from previous tries. However, just because we've always done something a certain way is a fact. It's not a reason. Then finally, review ideas with them. Remember, they often know where the skeletons are buried. However, watch for over-dependency on your part. You know, we will all have less experienced employees that report to us during our career. Keep in mind that there are some excellent, highly energetic people that we can tap into, and we can and do grow our own. Expectations convey enormous messages to these employees, so expect their success. Every employee in every position should have something that they own. Ownership is crucial to job satisfaction and growth. Even new employees need to have something that they own. They need to be problem solvers. They need to be thinking on their own and dealing with people issues. Now, be cautious of teaching newbies dependency on you. Watch for upward delegation and hold people accountable. Years ago, I had an assistant that I had asked to take over FMLA administration. And the first month, she sat down with me and I showed her exactly what to do, and she took copious notes. The next month, she came back to me and said, Becki, would you help me? I want to see this again. And so I said, sure, that's fine. We went through it again, and she fine-tuned her notes. The following month, she came back to me and said, can you show me one more time? And all of a sudden, I realized she's delegating her work back to me. So of course the answer was no, you need to go ahead and handle it on your own. You've got good notes. When you get stuck, ask me. Be careful of those things because they'll easily give you the work back if you allow them to. And finally, be prepared to deal with hesitancy on their part. You know, they're human beings too. They're nervous. They're trying to get used to things. Use their mistakes as learning tools, not battering rams. Now, with the remainder of our time here today, we will start delving into some basic employment laws that each supervisor should be aware of. The first of those laws is equal employment opportunity. Now, each one of you should have an EEO statement in your company's handbook. It should be a policy of yours. And essentially what it says is we're not going to discriminate against you in any employment fashion because of certain classes. And you'll see here that they're listed, everything from race, color, religion, national origin, citizenship status, age, disability, handicap, sex, marital status, veteran status, genetic information. Oh my goodness, it just seems like the list goes on and on and on. And it does. And here's the thing, we're going to keep adding to that list. And you know why? Because there are still people in our country that are not doing the right thing. They're not hiring people based off of the skill set that they bring to the table and whether or not they can do the job. They're hiring them based off of other factors, or sometimes not hiring them based off of other factors. It's still very lawful to ask for education, experience, skill, work history. Those are actually the things that we should be looking at. We should not even be considering those other elements. So the law specifically tells us under Title VII that there are certain protected characteristics under the law. These are characteristics that you should not be basing employment decisions on at any level. You shouldn't be offering a job to somebody or hiring somebody based off of these things. You should not help them become more successful or keep them from success based off of these things. You know, race and skin color, those are actually two different things under the law. National origin, religion, sex, age, disability, military status, parental status, arrest and conviction records, and off-the-job lawful use of products. Now, depending on what's going on in our country, we tend to see an ebb and flow of different characteristics here that have higher claims with the EEOC. So for instance, after 9/11, we saw a peak in our national origin and religion claims. After the Me Too movement really took off a few years ago, we saw a peak in sex claims. Now, if I was a betting woman, I would say that post-COVID, we're going to see an awful lot of religion claims. So it really does sometimes depend on what's going on in our country as to the number of claims that we're seeing and their percentages. So we have protected classes, but what sometimes we overlook is that we also have protected activities. And basically, this is protecting an employee when they decide to exercise their rights under the law. So if you have an employee that files a harassment claim, or they file for family medical leave or military leave, anything that is their right under the law, you are not allowed to hold that against them or use that against them in any employment fashion. So let's talk about some typical discrimination situations that we see. Well, it can be anything from failing to hire someone to not giving them a promotional opportunity, not sending them to conferences or training. It could be a layoff situation. You know, when you're going through a reduction in force, this is a really good time to make sure you're employing a third party like Landrum HR to help you go through and really analyze how you're coming to your layoff decisions. Because trust me, someone else will do that later on, and you'll want to make sure that you've minded all your P's and Q's. Now, under the law, there's 3 different types of discrimination. Disparate treatment is what we often think of it when we think of discrimination, probably because it's a little bit more black and white, and there's some intent behind it, or there's kind of a heart behind it. A good example of this would be, let's say that you have a handbook policy that says after 3 times of being late to work that you're written up. And you have a Caucasian assistant who has been late far more than that and never been written up. But then you have an African American assistant who is late 3 times, and you immediately write her up. That was the moment that you decided to fully enforce your policy. Well, that would be disparate treatment because you're not treating them the same based off of their protected class. Now, disparate impact is a little bit different. And what makes this one different is that it's usually coming from a neutral employment policy. There's usually not a real heart's intent to do wrong here. Nevertheless, discrimination is still taking place. A good example of this might be if you had a warehouse position that you needed to fill. And maybe, unfortunately, you just haven't reviewed your job description in the last 20 years. And 20 years ago, it required a regular repeated lifting of 100 pounds. And so you send your old outdated job description to HR, and they use that job description to post the job advertisement. So even though so much has advanced so that machinery is taking a lot of that heavy load now, and really you only need maybe 20 pounds of lifting every once in a while today, that posting still says a regular lifting of 100 pounds. Well, who are you going to adversely impact? Well, you're going to adversely impact mainly your elderly applicants, possibly your female applicants, and possibly any disabled applicants that otherwise might have been able to handle 20 pounds every once in a while. So the discrimination is still happening, the adverse impact is still happening, but there might not have been a hard intent to it. So it's still illegal and it's still wrong, and you need to be careful of that. And then the final area is undertaking or failing to undertake certain actions. So a good example of this one might be if someone comes to you with a sincerely held religious belief and is asking for accommodation, and you blow them off and you don't look into it. Or maybe it's a reasonable request and you don't grant it. That would be a form of discrimination as well. All right, we're going to move right along to the Americans with Disabilities Act, or what we call ADA. And for many of you who do not have 15 employees or more, this is not going to be something that you have to comply with right now. I still would ask you to make sure that you're paying attention to this, because you very well might breach that threshold soon. And even if you don't, you're going to have employees that work for you that have worked for other companies in the past that did have to comply. And it's best for you to be able to intelligently respond to their concerns. So this does cover employers with 15 or more employees. And as a general rule, it basically says an employer may not discriminate against an otherwise qualified disabled individual because of the individual's disability. Now, they define otherwise qualified disabled individual as an individual with a disability who can perform the employer's essential job functions with or without reasonable accommodation. Now, although the general rule is quite simple, it can also be a little bit difficult to actually employ. So we're going to look at the general rule and break it down. What types of discrimination does the ADA prohibit? Well, everything from people who are actually applying for your job. So if you have someone who's hard of hearing, you may need to provide an interpreter during the job application process. If you have someone who's visually impaired, you may need to actually have someone read the job application to them, or provide a magnifier, things of that nature. Anything to do with your hiring process needs to be ADA compliant. Promotional opportunities as well. You need to make sure you're not overlooking the individual who has a disability for promotion. When you're discharging people, are you conveniently discharging those that you've had to make accommodations for? Compensation, this is one that I see quite a bit, unfortunately. Well, they're not going to go anywhere. It's going to be harder for them to jump ship. So I don't feel the pressure to pay them as competitively as I do the other individuals. Very wrong. We want to stay away from that. You need to pay them market rate. Same thing for training, and I will say training is probably the one that I see the most violations from pretty well-intended employers. It's they don't need to have to go through all the energy to go away to this conference. I'm not even going to ask them, or it's going to be much more difficult for them to leave and go somewhere. No, go ahead and ask them, and they can tell you if it's too difficult, but they should have all the same conditions and privileges of employment. And this runs the full gamut. So this is making sure they have equal access to break areas, making sure they have equal access to cafeterias, really any employer-sponsored program or event. Now, specifically with the ADA, they get really detailed in what they consider discrimination and who's liable. One of the interesting things about the Act is that they will hold you as an employer responsible for a staffing service violating it if they're hiring on your behalf. So be very careful. When you are looking at a staffing service or a leasing service, you need to make sure that you're not going with a fly-by-night company. They need to be a company that's been around for a while, that has many certified individuals on staff that understand the nuances of the law, because you will be held accountable if they violate it. One of the other things about the ADA that's interesting is they're very specific about not generalizing. So for instance, if your aunt's uncle's brother's cousin also had the same disability as one of your employees, you are not allowed to generalize and say, oh, well, they couldn't do this, or they could do this. No, you just need to tell the employee, this is what this job entails, and if you need a reasonable accommodation, I am going to ask that you come to me and tell me. But you allow the employee to tell you what they can and cannot do. And then it specifically talks about disabled relatives. So for instance, if you know that an employee or maybe even an applicant has a spouse at home that's bedridden, you can't assume that, oh, well, they're just not going to be nearly as productive because their mind's going to be back home where their loved one is, or they're going to miss an awful lot of work to care for that loved one. The reality is it might just be the opposite. They might be your most dedicated employee because they have so much riding on their shoulders. So make sure that you're being very careful that you don't use that knowledge, if you have it, against them in any way. And then employment tests. This is a sticky area. So many companies are wanting to engage in employment tests prior to hiring, and you certainly can do that. But these tests need to be validated. And when they're validated by a neutral third party that shows that there's a direct correlation between doing well on this test and being successful in that role. Now, if you give employment tests, you need to give them to everyone, not just the individuals that you deem as disabled or you think might possibly have a disability. And then finally, like most labor laws, retaliation is not allowed. So if somebody is disabled, you can't retaliate against them. If they choose to voice their concerns about wanting an accommodation, you cannot retaliate against them. Or if you've had to give them some type of an accommodation, you can't retaliate. So please keep that in mind as well. All right, so what does otherwise qualified mean? Well, it means that the individual possesses the required skills or qualifications for the job. So at no point does the ADA remove that. They still have to be able to do the job at hand. So for instance, if I am hiring for an executive assistant and it requires 100 correct words per minute typed, well, maybe this individual is in a wheelchair, but they're the most qualified person. I might need to raise their desk so that their wheelchair can get in under the desk and they're ergonomically sound. But I certainly am not going to say, we're going to do that, but yeah, you can just type 60 correct words per minute. They still have to type 100 correct words per minute. I might just have to change their environment a bit to enable them to do that. So it certainly does not take the qualifications away from the job. Now, what is considered a disability? This is really important because we need to know what the Act says, not what we feel as individuals. And they say that it's a physical or mental impairment that substantially limits one or more of an individual's major life activities. So a major life activity would be something like, can they get themselves ready in the morning? Can they drive a car? Things of that nature. This does not encompass every ailment. This is not something that, you know, somebody has a physical ailment, but it doesn't impact a major life activity. They go on to say that if someone has a record of such impairment, they're also covered. They're also protected. So maybe you have someone who had serious back issues beforehand, and then a radical new surgery came out and they were able to fully heal, and they actually no longer have any major life activities that are limited. So they currently don't have that, but you view them now as, oh, they used to have that. Maybe they'll have that again. So maybe I treat them a little differently. Maybe I choose not to hire them or promote them because I'm worried that situation is going to come back in the future. You cannot do that. And then finally, being regarded as having such an impairment. And I know it kind of feels like, man, they're really stretching here. This is a real overreach, but I promise you that it's not. There's really good reason for this to be in the law. And I'll give you a personal example so that you can better understand. When I was getting my undergrad, I was about to study for my last test for my last class. And I decided that morning, it was a Saturday morning, that I was going to go for a walk before I hit the library. And I took a different route than I normally did. And long story short, there was a guard dog that decided to make me lunch and attacked my knees pretty severely. And I couldn't walk for a little while after that. And then when I did, I had to go through a lot of therapy. So months down the road, I am healed, and I certainly don't meet the requirement of having a disability where it would limit any of my major life activities, and I need a job. And so I went to a major health system to start interviewing, and went through several different rounds of interviews and got to the last round with 2 other individuals. And they said, hey, listen, we want to see your presentation skills. And so we're asking you to present a 15-minute presentation to our board of directors. You can pick any topic, just 15 minutes. And you know, I wasn't worried about my topic, and I certainly was not worried about my presentation. You know what I was worried about? I was worried about standing up from my seat and walking to the podium, that my gait might still be a little off, that they might think there was something wrong with me and choose another applicant over me. So those are the things that this law was trying to protect people from. And so it really is a good law when applied correctly. All right, so there's always an awful lot of questions about the Americans with Disabilities Act and how it interacts with substance abuse in the workplace. So I want to clear that up very simply for you today. The ADA does not cover any applicant or employee who is a current user of illegal drugs. Now, individuals who've successfully completed a drug rehab program or who are currently undergoing supervised rehab are covered under the ADA, so you can't discriminate against them. But that is providing that they're not currently using. Now, alcoholics, even those who have not been rehabilitated, are covered under the ADA. Now, reporting to work under the influence of alcohol or possession on the job or excessive absenteeism due to intoxication are not protected. So essentially, you know, you could have an employee who you know is an alcoholic. Maybe they're at the bars by 5:30 every day and they're inebriated, you know, by 7. But they're coming to work on time, they look appropriate, they don't smell of alcohol, they're producing at the same level as everyone else. You can't hold that against them because it hasn't breached work. When it breaches work and you start seeing excessive absenteeism and you start seeing productivity go down and things of that nature, then you can address those issues specifically. All right, so let's see here. Some other things, you know, just keep in mind that you can prohibit the use of alcohol or illegal drugs in the workplace. So you absolutely can still do that. You can require that employees not be under the influence at the workplace. And you can still discipline or discharge current users of illegal drugs or illegal use of controlled substances, even if the employee is not under the influence. So employees who test positive can still be discharged. And you can hold a substance abuser to the same job performance and behavior standards as anybody else. So your standard should not change, and the litmus test for this should not change as far as employee behavior and productivity. So what are essential job duties? Well, simply put, they're the reason that the job exists in the first place. So an essential job duty, for instance, for a driver would be driving. For an executive assistant would be typing. But certainly if you have an executive assistant who now has a disability that keeps her from driving, and let's say she had a run to Office Max every quarter, well, that's so infrequent, and someone else can certainly do that, that although she can't drive anymore, you could easily give that job to someone else. That would not be considered an essential job duty. But if she had a situation where she could no longer type and there was no other means about getting that work done, that would be considered an essential job duty. So what is a reasonable accommodation? Well, a reasonable accommodation can look very different in different situations, but I will tell you this, it's rarely ever something that is kind of a blow your mind situation. I've been doing this for well over 25 years, and I honestly have never had a situation where, you know, hundreds of thousands of dollars were spent, and it was just a terrible hardship for a company. Typically, they're really simple fixes. One most recently that we had with a client was a gentleman who is in renal failure, and he needed to go through dialysis, and I didn't even know this until the circumstance came up, but apparently there are sometimes they can send home some dialysis machinery for people to do it at home. And so he came to his employer and said, listen, I need several times throughout the day to do this in order to keep up my quality of life. And they simply changed his work hours. He normally came in at 8. They said, hey, come on in at 7. We'll give you some extended breaks throughout the day, including your lunchtime, so that you have the appropriate time to handle this. And we'll give you a private place that's free of intrusion, so you feel comfortable while you're doing it. So as you guys know, right now it's hard to find employees. He was a good employee. He still is a great employee. They have bred extreme loyalty with him now, and they've been able to keep and retain a really great employee. So it really was a win-win. If you hear nothing else that I say today about ADA, I hope that you will take this away. And that is simply that when someone comes to you and requests an accommodation, what I'd love to see you do is hand them their most up-to-date job description and ask them to go see their specialist and ask their specialist for different accommodations that may be viable for this particular job. You're going to do that for a couple of different reasons. One, certainly if it's a specialist in that area, hopefully they'll have several different options for you. And the law is very specific that the employer can be the one to choose which accommodation they try first. You do not have to go with what the employee wishes to do first. And so you might be able to choose a less expensive or a less difficult or less complex choice. The other thing is, God forbid that they come back and say, listen, I just don't know how this job will ever get done given the disability at hand. Then that's something that you should hold on to in case that person loses their position or is moved to another position and this ends up in court one day. Because if it does and your counsel is worth their salt, the very first person they'll put on the stand is going to be that specialist. And they're going to ask that specialist, hey, where did you go to residency? And, are you board certified? And how many hundreds of these types of patients are you seeing every year? And are you eating, sleeping, and breathing this type of condition? And of course, the answers to those are going to be yes, yes, yes. And then they're going to simply look at the jury and the judge and say, yet somehow you believe that this employer should know better, that this employer should have come up with an accommodation that this individual specialist could not. And hopefully that will be a slam dunk for your case. So make sure that you're doing that. That's always a very good practice. So what is an undue hardship? Well, as most things that come out of DC are, they're very ambiguous with this, but the threshold is high, I will tell you that. So not only will your facilities, financial resources be looked at, but also your entire companies. And it doesn't matter if you're not for profit. So I had a church recently that asked, hey, we have a $10,000 request for an accommodation. We don't think we can do that. We're not for profit. And I had to remind them that they have millions of dollars running through their system annually. And so this was not going to hold up as an undue hardship. So be very careful when looking at this. If you think you have a case for undue hardship, again, employ your HR business partner if you're a Landrum HR client, or if you're not, make sure you're getting your own HR team involved in that conversation. So let's get really granular here for a minute. What kinds of inquiries can you make under the ADA? Well, certainly you cannot ask them if they have a specific disability. You cannot ask them how many days they were absent last year. And honestly, that was something that was asked on applications not too long ago. You can't ask them if they have mental health problems or what drugs they're taking, prescription drugs. But what you can do is you can hand them that copy of the most up-to-date job description. And you can ask every single person, hey, can you do this with or without a reasonable accommodation? And let them tell you. You can ask them to demonstrate how they would do the job. Now, if you do that, make sure you're asking every single applicant or every single employee. Don't just ask the person that you believe has a disability. You can certainly ask them if they can attend work regularly. You can still ask for certain licensure and accreditation, things like that. But just be careful that you're keeping it very job related. So it's still very okay to ask for so many years of experience. It's still okay to ask for certain skill sets. But what I want you to hear me say is that if you're going to hang your hat on something and say this is an essential job function, please do not consider that it's lumped into that other duties as assigned in your job description. It will not hold up in court. So if it's valuable enough that you would take an employment action against somebody or change their job or even eliminate their job based off of this particular job duty, it needs to have its own line in your job description. You know, there's a lot of different factors that go into determining essential functions. You know, a function may be essential because the reason the position exists is to perform that function. It could be essential because of the limited number of employees available to handle it, or it could be essential because it's highly specialized. So if you're determining that, these are some good questions to run through. All right, in the essence of time, we're going to move right along to Family Medical Leave Act, or what many people call FMLA. And this is protected leave. This is up to 12 weeks of protected leave for any eligible employee for a qualified event. So it will guarantee reinstatement to the same or similar position. It will also help them maintain their benefits while they're out. So how does somebody become eligible for FMLA? Well, of course, obviously they have to be an employee, but they also have to have worked for the company for 12 months. Now, this is something that I see a lot of even seasoned companies fall down on, because they seem to think that that says the last 12 months, and that is not the case. This does not have to be a consecutive 12 months, just in a total of 12 months. Now, within the past 12 months, they do have to have worked 1,250 hours. And then they have to work in a location that has at least 50 employees within a 75-mile radius. So what kind of events qualify for FMLA? Well, it could be the birth or care of a child. It could be the adoption of a child. And keep in mind, this is for men and for women. It's not unique just to women. It could be the care of a spouse, a child, or a parent with a serious health condition. It could be that the employee has their own health condition. And it could also be a qualifying exigency for family members of the regular armed forces, the National Guard, and reserves when the covered military member is on active duty or called to active duty. So essentially, here in the Pensacola area, we have a heavy military population. And so if one of the employees were to come and say, listen, my spouse is being called up to duty, and there are elements that I need to take care of, maybe we need to go seek an attorney's help for updating our will. Maybe we need to take our children who are having a difficult time with the news of the deployment to seek a counselor. Maybe we need to take care of some financial things of that nature. That would fall under this FMLA. To go as far as to say, if the deployed individual, for instance, were taking care of their parents prior to that, well, now that duty is going to fall on the spouse's shoulder. So they could even take FMLA for that. Now, the FMLA also has a 26-week leave coverage for those people who have a next of kin covered service member with a serious illness or injury incurred in the line of duty. So this could be, a son or daughter that comes back from overseas and unfortunately is missing a limb, and they're having to go through a great deal of recovery and therapy and rehab. Obviously, the parent would want to be with them, so they could certainly do that. This one has not been utilized nearly as much, and I'm thankful for that we haven't seen a lot of this usage, but please do know that it is out there and is available to your staff. Now, the law does say that you can calculate the 12-month period for FMLA one of 4 ways. It can be a regular calendar year. It can be any fixed 12-month period. So it could be your fiscal year. If you're in an educational setting, it could be a school year. It could also be a 12-month period starting with the FMLA start date. And it can be a rolling 12-month period measured backward. Now, we highly recommend that you go with a rolling 12-month period measured backward, and I'll tell you why. If you go with a fixed period, for instance, let's just take January through December, a regular calendar year, eventually your staff are going to be very smart, and they're going to realize there's the possibility they can get far more than 12 weeks consecutively. So if I know as an employee that it's a January through December calendar year, and I can push off a much needed surgery, if I can push that off to October, that really is in my best interest, because if my 12 weeks runs, but January 1st, my 12 weeks starts over again, there is a possibility I could get up to 24 weeks. Now, as you know, as leaders, it is difficult to even go 12 weeks without a needed position. So this actually puts you in a much more vulnerable space, in that you could possibly have some that go as long as 24 months. So we highly recommend that you make sure that you're utilizing the rolling 12-month period. If you're currently using one of these other methods and you want to change it, feel free to do that, but make sure that you make an announcement about it and you change it in your policy so that people know that you're drawing a line in the sand and you're moving forward in a new way, so that no one can claim that you're discriminating against them if they're one of the first ones that's being applied to. All right, so FMLA is not paid leave, and that is a big misnomer out there. A lot of your employees may very well feel like it is. It is not. It's protected leave. Now, the law does allow for you to overlay any PTO, sick, or vacation time on top of their FMLA so that they use that up while they're on it. Of course, once they use that up, it would be unpaid leave until they're done. And we encourage that you do that. In fact, many of our clients have that as a policy of theirs, and we strongly encourage that. We certainly don't want you to be in a position where you've had someone out for 12 weeks, they come back, and because they haven't tapped into their PTO, they then put in for another 2-week vacation to Europe. You certainly have needed them. There's a reason you have that position open. The business runs best with that position, and so we don't want you to be put in that vulnerable space. All right, so when somebody needs leave, the law does say that if foreseeable, they should be giving you 30 days advance notice. Now, the reality is, for those of you who are on this call that have had some time under your belt as a supervisor, you know good and well that rarely happens unless it's in the case of pregnancy. It's very hard to prove that somebody had foreseeable time, and some of them just don't, in fact. But what will happen is a certification for healthcare provider will be sent to them to get to their doctor to fill out. And you should know this is not a 1 or 2 pager. This is multiple pages. It's a very extensive document, and it will tell us all that we need to know if they qualify for FMLA and what the time frame looks like. After that, certainly if you're a Landrum HR client, we advise you to get that paperwork right back to us so we can determine whether or not they qualify. If not, make sure you're utilizing your own internal HR team. And just as a healthy reminder for everyone, if you have spouses that are working within your company, the law does not require that you give them each individual 12 weeks of time off if it's for the same situation. So for instance, if you have a couple and they're adopting a child, they will share that 12 weeks according to the law. Now, can you be more generous as a company? Absolutely. If you want to be more generous, as long as you're being more generous across the board to everyone, you can allow them each to have 12 weeks. But just know that you don't have to do that. If that's cumbersome for you to have 2 people out like that, then you can certainly make them share that under the law, and that's just fine. Now, intermittent leave is the nemesis of FMLA for supervisors. This can be someone who just needs a periodic treatment. It could be someone who needs therapy every once in a while. It can be flare-ups to chronic conditions. But intermittent leave is hard because it's one of those things where you just never know, so it's hard to plan. When they can plan, if it's a doctor's appointment type of an issue, they need to be able to tell you that in advance. They still have ownership to communicate to you as their leader. However, there's some of these things you can't plan. And one of the things we've seen a great deal of in the last couple of years is depression and anxiety. And for those of us who've had a loved one who's walked through clinical depression and anxiety, it's a very hard thing. It's a very serious thing. It's hard on the employee, but it's equally as hard on the leader, because that employee might go to bed at night and feel absolutely fine, but they might wake up at 6 o'clock the next morning and not be able to get out of bed because their depression is upon them. And so that puts the leader in a position of constantly having to regroup and try to get coverage at the last minute. So if you're dealing with those types of things, remember, first and foremost, do not make the employee feel bad for that. This is their right. It would be considered retaliatory to make them feel poorly for it. But also make sure you're getting with your HR business partner. We have ways to help you manage those things to make it a little bit more palatable, because we do understand how difficult it is. So there are some very specific things that you are prohibited to do under the FMLA. First and foremost, you're prohibited to ask pre-hire inquiries. So you can't say things like, well, how long have you taken FMLA in the past? Or how many times have you taken FMLA? Or do you think you're going to need FMLA in the future? You can't ask those kinds of questions. And then for those of you who have a good attendance award, and many of our blue collar clients do, especially in production settings where it's critical that everybody be at their station every day to keep production high. You might have an attendance award at the end of the year for everyone who's not missed any days. Well, if you have someone who's not missed any days except for the days in FMLA, you still have to give them that bonus. This is a very specific thing noted in the law, so be aware of that. And then, of course, you don't want to ask an employee every single time they go out on intermittent leave for a doctor's note. Under the Act, that is considered harassing, and they could file an EEOC claim against you for that. So what do we do in this circumstance? Well, we need to look at that certification for healthcare provider and see what kind of time period the doctor assumed they would need. So let's say the doctor said, hey, for 6 weeks, we think they're going to need intermittent leave. Well, if the employee is then asking for more time beyond that 6 weeks, then we can certainly ask them to go back and get that doctor's note updated. However, right now we're seeing a lot of just indefinite time periods on these on this paperwork. So a lot of times it's just indefinitely or as needed. So in that case, the law does allow for us to ask every 6 months for an updated note from the doctor. To do so earlier than that, unless there's a defined end date that's earlier, would be considered harassing in nature. And of course, we can't interfere with an employee's rights under the family medical leave. And keep in mind that this is one of those laws that you can't stick your head in the sand on. It says very specifically that should a reasonable person know that someone could need FMLA, it's your ownership as the employer and as the leader at your employer to tell them, hey, listen, remember, you've got family medical leave. Let's contact Human Resources and see if you qualify. All right, you can't ignore it in hopes that it'll go away. Again, that reasonable person standard will be applied. And of course, you cannot retaliate against an employee who files FMLA, who files a complaint, who asks for FMLA, or who has recently taken FMLA. So just be very, very cautious with that. And so what would happen if you did violate FMLA? Well, the potential is that you could pay back pay and possibly overtime, liquidated damages, prejudgment interest, and attorney's fees. And you guys, that's an awful lot of money. That's big dollars right there. And it's so unnecessary. And beyond that, it also could be your reputation in the community. So be very careful that you're following the law as it's written. If you have questions, that's what we're here for. This is the kind of stuff that we eat, sleep, and breathe, and we would love to help you with it. FMLA can be very tedious. I tell people all the time that if I ever hear someone say, oh yeah, I handle FMLA and it's not a problem, I always think to myself, I don't think you're doing it right. Because if you're doing it right, it is an awful lot of work. And so of course, here at Landrum HR, that's part of the work that we take off of your plate and handle in-house for you. So please make sure you're utilizing us to the full degree because that is what we're here for. All right, well, everyone, that concludes our session for today. I know it was an awful lot of information. We will be continuing this series in our next session, which I believe is scheduled for Thursday, May the 19th. Since we had such a packed hour of information, we weren't able to get to all the questions as they came in today. But if you have given us a question today, rest assured that you will be answered via email within the next couple of business days. So we will be getting back to you on that. Here at Landrum HR, we exist to make sure that your business runs easier and that the business of people is easier. So if we can assist your company with any of your people needs, we hope that you'll reach out. Until next time, have a great day, everyone.